welcome to another edition of the program Familiarise with the Law, coming to you from Star Television Channel 21, where we broadcast live from our Media One Center, 3 Member Street, Oakfields in Freetown. My name is Abdul, Rahman, Kamara. My guest in the studio is Barrister Hedrain. Mr. Fisher, welcome to this program.
Good afternoon to you, Brian.
Great. In the national electoral system of any country, the establishment of public election guidelines and principles are very much critical in ensuring a fair, credible and peaceful election, for which the outcome of such election could hardly ever be disputed when all of the structures are being perfectly placed. It is against this backdrop that today's discussion will focus principally on the Public Election Act of 2012, which is central to the current political dispensation. We've got a lot of laws, so many laws that has been formulated that could aid the process in ensuring that the outcome of this 2018 election could not be anything that could raise a kind of eyebrow or better put, being disputed. We've seen a whole volume, perhaps you may call it a compendium of electoral laws by the judiciary of Sierra Leone. What's the original intention behind the formulation of some of these electoral laws?
Well, as you're aware, Sierra Leone is a democracy, and one of the fundamental tenets of democracy is free and fair elections, in addition to principles of the rule of law. And elections that are not free and fair are considered to be undemocratic and not in accordance with those rules. So the idea of election laws are nothing new. They are there to ensure that there is a process, a verified process that would stand up to scrutiny should there be a dispute. So in Sierra Leone, for example, we have a number of laws to deal with elections, but the most important one from our point of view is the Public Elections Act of 2012. Notwithstanding, we have the Constitution as well, which deals with elections, but specifically, so far as elections are concerned, is the Public Elections Act of 2012, which was enacted by Parliament back in May of 2012. If we recall, Sierra Leone did have elections in November of 2012. So that law repealed the existing law, which was the Elections Act of 2002. And it is that law that is now the current law for elections, governing public elections in Sierra Leone.
Perhaps what seems to be pretty much of a challenge is the consummation of these laws, for which its generic objective is to avoid electoral anomalies. How much people tend to understand some of these laws, because I understand that if you tend to default, the resultant effect is that when you are found guilty by a competent court of law, you will be penalized either for not voting or voted for in this regard.
Well, that's right. In fact, the Public Elections Act does have a total of 26 separate offences which are set out in that act. And some of the penalties that are associated with breaching any of those laws involve being banned from voting in the forthcoming elections, and also being banned for a period of 5 years, which means that effectively you're barred from registering as a voter and voting at the next elections. So in certain circumstances, if you are caught under some of those offences, you'll be in a position where you don't vote this election and the next election, which means you're effectively disenfranchised for a period of 5 years.
When do you, in your view, think that actions will actually commence that will result to a penalty being imposed on the individual? Could it be a situation where during the election or immediately after the election, or before?
Well, no. The Public Elections Act, the offences are set out in different categories and periods, if I may say. You have offences that relate to the pre-election period, i.e. registration of voters, for example. You have offences that relate to, like, for example, what we have now, the campaign period. That is during the period where political parties are actively campaigning for votes. There are offences in relation to those. and you also have offences on election date. And in fact, one might say that there, by extension, there's a fourth category, i.e., offences even after the election has happened. So there is a wide variety of offences that covers the election period, or if you like, the election cycle.
Okay, I was just looking at part 8 of the Public Election Act that deals with so many questions, which ranges from questions as to elected member of parliament to be determined by the High Court, election valid until questions within 21 days of publication of results, presentation of election petition, trial of election petition, proceeding to have priority of hearing and non-compliance with the Act. All of this put together, perhaps what seemed to be delicate in this regard is how much people tend to understand, because it's like a greater concentration, and even the political parties for which they have the responsibility to thoroughly educate their supporters and sympathizers on some of these laws. And the indication is one may falter along the line. He never knew as to whether he has done something wrong with respect to these election laws. So how critical and central is education in all of this? Do we have time?
Well, yes, we do have time. I think there are a number of problems, but I think I just deal with two. One, there's a general lack of knowledge about legal provisions in our country. Many people are just aware of the nuts and bolts, i.e., I cannot stab somebody, I can't fight somebody, I can't kill somebody, but as to what goes beyond that, they have no idea whatsoever. And you have a situation where there's inadequate sensitization, if you like, of the populace in relation to these offences. I mean, just quite recently, I've been following on the media all of the discussions in relation to the elections. And clearly, it's occurred to me that nobody seems to be focusing on what offences people can commit during the election period. All you hear is about who this flag bearer is, what that flag bearer is doing, what is happening, the internal dynamics of the political parties. Of course, we had the Tusim debate and all the rest of it. But nobody is saying, well, look, these are the offences, these are the penalties that you can face should you be in a situation where you are caught during this election period. And I think it's very important, because if people understand that, some of the conduct that has been associated with previous elections need not be repeated. For example, in way back, we've had elections in this country every 5 years since independence, and apart from during the war period, obviously. We've had people who just think that certain types of conduct, like, for example, we're not going to allow that political party to come and campaign in this area because this area belongs to us.
It's no-go zone.
It's a no-go zone. So you don't come here with your own party, because we'll destroy your vehicles, we'll tear down your posters and all that kind of thing. And such conduct, which in the past had been associated with elections and which people have come to expect to be the norm, such conduct is no longer tolerated under the Public Elections Act. And if you disrupt the lawful meeting of a particular political party and you are caught by the police, then you face a sentence of a minimum fine of 5 million leones or 2 years imprisonment. So the question is, why would anybody want to put themselves in a position where they would have to pay minimum of 5 million leones or face going to jail for a period of 2 years? So it's just not worth it.
Again, I was wondering as to whether we have within the expected bracket of expectation this aspect of the dual SIM that you mentioned inter earlier, whether it goes, well, the Public Election Act has that mandate to actually look into those issues critically and adjudge as to the legality of short claims, whether somebody contesting the candidacy of an individual, or it is just the reserved opinion of the court to make your decision, which is which.
Well, clearly, Sierra Leone is a democracy, and we are governed by the rule of law. And one of the things that's fundamental in so far as the rule of law is concerned is having access to the courts. Now, where there is a legal dispute, the proper forum to deal with that dispute is in the courts. I mean, many a time people think that, well, going to the court is a waste of time. But no, going to the court is not a waste of time, because going to the court reinforces our credential as a democratic country that is guided and governed by the rule of law. And it is for this reason why the Public Elections Act effectively deals with everything to do with elections, i.e. from registration of voters to what happens during the election process, to nomination, to the actual election day, to the counting of votes, and then to petitions that are coming up after the elections, and then to appeals. So it's a cycle, and no one part of the election process is more important than the other. So it's a package, and this is what people need to recognize, that wherever there is a dispute in whichever part of that cycle, then the proper forum to deal with that dispute is in the courts. And we need to respect the verdict of the court when a decision is given.
Again, a couple of months back, I was having a privileged discussion with an official from the National Electoral Commission, that is Albert Massakoy. Well, he's out for public consumption anyway, on the establishment of an electoral court, which presupposes that there are already cases that have been put forward before the court for onward, adjudication, ranging from minor offences, where I really don't know what constitutes minor offences, but an offence is an offence, as long as it borders around the expected norm of a society. Now, the indication is judges have been appointed. The last time I was talking about a supervising judge, Justice Monfred Sase, I think he is responsible to undertake some critical exercise before the actual commencement of that court. That court, Adrian, does it have the legality, the binding elements when we think of what the appeal or the high court could actually have within its jurisdiction?
Well, I think firstly, viewers need to understand that the establishment of the courts is a constitutional requirement.
Okay.
The Constitution itself makes provision for the High Court, which is effectively what the Elections Court is.
Mm-hmm.
The Public Elections Act, in fact, even the High Court rules allows divisions of the High Court to be created.
Okay.
For example, we have the Commercial and Admiralty Division, the Land and Property Division. So the High Court has divisions that deals with different matters. And one of these divisions in the High Court is the Electoral Offences Court. And what that court effectively does is staffed by judges. So it's a High Court, like for all intents and purposes, every other High Court. The only difference is this court is charged specifically to look at complaints in relation to an election. So that is where the legality comes from. It's a constitutional requirement,
okay,
and it's also reinforced in the Public Elections Act.
I have not taken my time off to look at all the manifestos in-depthly, but it is within the manifesto, that is the political party's manifesto, where commitment, I underscore the word commitment, has been made in ensuring that the justice system in the country is critically looked into, perhaps by way of uplifting the justice system. I know there are challenges, but yet still we're making strides as a nation. But there ought to be improvement, especially the sitting capacity of the current court sitting that we have, the speedy expedition of cases. You remember there are a lot of litigation congestion in courts. It could be on land, it could be on many issues. All of those things don't seem to be taking central stage when it comes to. This morning I was at AYV, and the discussion centered around the journalists, us, the media practitioners, setting the agenda for politicians, for which I want to say all of us feel woefully in that regard, because we allow the politician to set the agenda and we follow them blindly. Issues like resource management, issues like how they ought to actually up their effort in ensuring that we have a solid justice system in the country. I am amazed. I am amazed. When I've been looking at newspapers, people were jollifying as a result of us having now a British judge coming into this country to adjudicate all matters, as if our judges are not competent, or as if, well, one may want to ask a question: what is wrong with us? It could be capital intensive, that's for sure. That it could be one of the very many reasons. But the point is, as a nation, we've gone far ahead to having take control of our justice system to a point that we can determine what we really want to achieve at the end of the day. All of those things, politicians ought to actually commit themselves in ensuring that they package their manifestos towards having a fair justice system in the country. I know it's a Herculean task.
So, what exactly is the question?
The question is, we are not pleased with the current disposition as far as the justice system is concerned. I have said this often. When I look at the Oscar Pistorius case in South Africa, even the court sitting is pretty much encouraging. But here you go, it's just the same. And this is a commitment people have been saying we are committed in ensuring, and we have all of those things could have a downsize in the expedition of our cases. So, are you pleased as a barrister? Are you pleased working for the judiciary? There are brothers and sisters out there for which you want to come and give service, but because of the prevailing circumstances, they could not come. So if you ask me for a question, I think this is an observation that I'm sure is pretty much shocking to an extent that you will not expect a question coming directly from me. Perhaps your comment.
Right. Well, that's quite loaded, I have to say.
Yeah.
And I think we, as a country, we need to be realistic where we are. We cannot compare.
Are we satisfied?
Well, the question of satisfaction works both ways.
Mm-hmm.
We can be satisfied in one aspect and be dissatisfied in some other aspects. But I think we need to be, as I said, realistic where we are as a country. Also, we have to be realistic where we are with resources. Also, we have to recognize the efforts that others have made and are making towards the ultimate goal, which you've just mentioned, i.e. satisfaction. Running a judicial system is not easy. I think we have to bear in mind that countries like the UK, for example, they've run a judicial system for the past 400-500 years. So they are well versed in running judicial systems, and they continue to improve on a daily basis. We inherited a colonial system, a colonial judiciary, if you like, from the UK. And yes, there have been strides to improve the justice system. One of the problems, I mean, if I may just say this, when I came to Freetown for the first time, after having been away for a little while, there were only 3 magistrates in Sierra Leone at the time, just after the war. We must not lose sight of the fact that there's been a war, which has caused a lot of problems. The rule of law was totally broken down during that period. There were only 3 magistrates at the time. Now, as I speak, there are magistrates in every district in Sierra Leone. At the time, there was only 1 law court building. As of now, there's a magistrate court at Padembe Road. In fact, I think there are 3 or 4 magistrate courts at Padembe Road and at Ross Road as well. So that is an improvement, because in the past, magistrates could only deal with probably 10 cases a day, when the actual list of cases we had before was up to 80, 90 or 120 cases. So now the workload is more shared out. Again, back in 2003, 2004, you had probably less than 10 judges in the entire judiciary. Now, just recently, I think it was last year, the later part of last year, the president appointed 10 new judges. And again, this is unprecedented. So in some ways, we also have the question of now the establishment of a fast-track commercial court. So there has been improvement, but that does not mean that we have reached the goal that we want to get to, or we've attained what we set out to do. So, my impression of the judiciary, it is a work in progress. And also, there are further issues that need to be dealt with. I mean, everybody must take responsibility for our judicial system. It's not just a question of the judiciary alone taking responsibility. Lawyers need to take responsibility for the judicial system because they work in the judicial system on a daily basis.
How could that be done?
Admin staff, well, in terms of lawyers, they need to make sure they attend court. Part of the problem is that lead to congestion in the court is some lawyers do not attend court as often as they should. Sometimes they may be in another court when their matter has been mentioned in another court, which leaves the magistrate with a very little option but to adjourn the matter in order to give justice to the undefended litigant. So these are matters that need to be worked on to ensure that lawyers will be present when their matters are mentioned. And that way the system can move forward. So it is a work in progress. It's a question of us finding a fine balance to ensure that we can achieve those objectives without having a situation where justice suffers at the end of the day. So, I mean, looking at it in the round, I feel that from where we are, there's been tremendous strides, but we need to go a few steps further.
You're doing a very great job justifying most of the key interventions by the government in ensuring that the justice system is up to speed. But yet still, I reckon the fact that we ought to catch up with modern trend. What we see, I'm not saying we should have a kind of unnecessary anxiety, but it's just that there ought to be improvement, perhaps in the area of financing the justice system, more resources into the justice system. If that call is being actually beckoned upon, I'm sure it's just the beginning of us addressing some of the critical challenges of the justice system. That said,
yes, I agree with you,
yes.
Abdul Rahman. But as I said, this is why I premised my response to your statement that we need to be realistic where we are.
And that's the reason why I said you're doing a very good job justifying intervention of the government.
Well, I mean, I'm just looking at it from somebody that works, from the position of somebody that works in the system, somebody that has worked as a magistrate in this country for over 5 years, and I understand exactly what the problems are. And I see the problems on a daily basis. But again, one has to look at it from the point of view that yes, you may want to resource the justice system, but then in resourcing the justice system, what would be the net effect of that? Would it be the question that health would suffer? Would it be the question that education budget will suffer? So this is why I premise it on the fact that we need to be realistic where we are. Yes, there needs to be additional resources into the justice system. I mean, there's been a lot going in so far, but more needs to go in to bring it up to where we want it to be. For example, we want to see all our judges having laptops, all our judges having assistants, lawyers working with them, assisting them to do their research and writing judgments. Yes, we want to see all of that. But do we have the resources to be able to do that? So it will take time, and it will take commitment as well down the line to find the money one way or the other, either to donor funding or to our own resources to ensure that we can put those resources into the justice system.
Adrian Fisher, I recall a couple of months back when there's debates on dual nationality mooted up by no less a person and the man I often call Gabi, your friend, like Gabidon. You were in the studio. I brought a clip of an interview I did with Gabi. He was steadfast in holding this belief that the law is the law until it's either been annulled or denounced or reenacted. And I put forward this question to you as to whether you believe then you were winning the argument. On the affirmative, you said yes, you were winning the argument. But it's suggestive now, or indicative of the fact that I am not sure whether this argument that you claim to have won then is now in your own favor. Are you holding this conviction that you're still winning the arguments?
Well, I mean, what I said back...
Or Gabe is getting an edge over the argument?
Well, what I said back then,
yes,
I can't change. But what I certainly will say now
Mhm.
is that I hope to see the appropriate court, i.e. the Supreme Court, dealing with this matter, and then we'll be left in no doubt as to whose explanation is correct.
Why are we late going to the Supreme Court to actually have a final say on this matter?
I honestly do not know because if you would recall when we had that interview here, I challenged Mr. Gabidon on that we should file papers and go to the Supreme Court and we could have the matter determined there. And if I recall what his response was, he's too old to do that. If that's what I recall accurately. So as a result, he did not take up the challenge, which I would have loved for him to have done, because then at least we would have cleared up this issue. But notwithstanding, I mean, it may well be that somebody somewhere might decide to seek an interpretation in the Supreme Court. And it's only then that we'll be in a position to know what the law actually is. For now, everybody have their own interpretation. He has his, other people have theirs. I mean, many other people have stated opinions contrary to both myself and Mr. Gabidon. So it's a question for us to
Well,
debate and see.
I dare say it's too late now, especially where people have suffered immensely as a result of the application of the law. What is there in the 1991 Constitution? Especially for those that demonstrated the interest to contest for the seat of parliament. Within the political parties, ventures have already been taken to outdo them on the consideration that you hold dual nationality. So the deal is done, except we're looking forward to the incoming government immediately after March 7. Then us as citizens will provoke the issue, and maybe the next parliament will be keen to look deep into those absurdities, as I choose to use your word, those absurdities surrounding the 1991 Constitution, and by extension will have the onward privilege to review the 1991 Constitution. Are you of the same opinion now?
Well, it is difficult to say.
I tell you something.
Mm.
Lawyer Francis Gabidon is now walking tall in the street of Freetown.
Well,
I will imagine where you and Gabidon should have got a finding in court. I will not come to the conclusion, but it's pretty much obvious.
well, look, one thing I can say to you, Abdul, as lawyers, our task is to test the law. Our task is not to simply just adopt the argument of another lawyer, because every lawyer has their own approach to the law. So that is why the only proper forum for determination is in the appropriate venue, i.e. the court, and in this case the Supreme Court. And my argument with Mr. Gabriel was very, very simple, that using established canons of interpretation, i.e. what we call in law statutory interpretation, he could not win. And this was the argument that we had, if you would recall, when we had that discussion. So I would be happy for me and him to get into the Supreme Court and then he wins. I would shake his hand, because that is the true tradition of the law and the legal profession. If your colleague wins, you're happy for him.
And
There's no hard feelings.
This is where the court of public opinion has imagined to have been a winner of this debate.
Well, the court of public opinion may have its own views. I mean, we would recall. I mean, you see, as a lawyer, I do not listen to the court of public opinion. I do not take cognizance of what the court of public opinion says, because there's a reason for that. They are laymen, and we are trained in the law. So I would listen to what a colleague lawyer is saying, and I would obviously pay due deference to what a properly constituted court has decided after having heard all the legal arguments that have been put before them. So this is where my position is. The court of public opinion can say what they like. I mean, I remember there's been many cases in the past, for example, in 2005, if I recall, when Mr. Magai took a case to the Supreme Court challenging the candidacy of then former Vice President Berewa. The court of public opinion was of the view that Mr. Berewa could not contest. But when Mr. Magai went to court, the Supreme Court said no, he can. So this is why I do not listen to the court of public opinion, because many a time they'll get it wrong.
On a very serious note, I've been wondering over this question as to whether reaching a judgment in court, the consideration of public opinion is being factored in the line of judgment by any judge.
But the answer is no. Judges, by their training, do not listen to what the public have to say on a legal matters, or they ought not to listen to what the public have to say on a matter. I'll give you a clear example. Quite recently, we had the Brexit judgment in the Supreme Court in England. And this was a matter, as we all knew, the public had voted for the UK to leave the European Union. So there was widespread support for that to happen. And then one member of the public decided to take the government to the High Court. And she won in the High Court. And then the matter went to the Court of Appeal. She won again. And the matter went again to the Supreme Court. She succeeded again. The court ruled against the government on 3 separate occasions. And this prompted the media to label the judges as Judas, or Judases, if one may say, because they did not listen to the voice of the public. And the judges did not have to listen to what the public said, because they looked at the law, and as far as they were concerned, the decision that they came to was right and correct and proper in law. So the court of public opinion does not count. We look at what the court of legal opinion has to say on a particular matter.
Well, I will imagine a situation where in the future, Lawyer Gabidon will tell the young lawyer here, Adrian Fisher, think quickly in the future and talk slowly. But that said, I have a lot of friends. One among them is Solomon Jamiro. You have the likes of Lawyer Somikita Conte. This compendium of electoral laws and by the judiciary of Sierra Leone, they were telling me it saves time, especially for practicing lawyers, to avoid going with many books, wanting to make reference in court, but they will solely rely on just this compendium. How critical is it?
Very, very, very critical, and it's a laudable venture from the judiciary. And I'll say this. We have laws scattered all over the place.
Mm-hmm.
I mean, in that book, there's about 10 different legislation. So imagine if you have to go to court on a case and you have to carry 10 different legislation with you.
Mm-hmm.
The Constitution is one, the Criminal Procedure Act is another one, the Public Elections Act is another one, and many others. So it makes sense to have one book where wherever there is an argument in court, a lawyer simply has to open the relevant page and then just advance his argument to the court. And most importantly, the judge sitting on that case also has access to the same book, and he can follow up whatever arguments the lawyer is making. So it's an important venture, and I think it's one that should not just be restricted to the election offences and elections court, but I think books like this in the future would be helpful for other types of litigation. For example, commercial litigation, now that we have a fast-track commercial court, and even in criminal matters.
Do you see this possibility of having a ruling? I assume in this case, having a ruling on election outcome, where perhaps one political party felt pretty much dissatisfied with the outcome of an election, and rushed to the courts to put a hold on the election results until a competent court could look deep into the matter that was taken before it. Then the NEC, the National Electoral Commission, could eventually announce the winner of that election upon a judgment by a court.
It is not impossible.
It's not impossible.
I mean, going back to the year 2000 in the United States, we saw what happened. Bush v. Gore.
Al Gore.
Mm-hmm. Yes. And a judgment came out from the Supreme Court of the United States, which didn't allow Judge Bush to become the president. So, in the event that after the elections are held, anybody is aggrieved, the law is very clear. You can file a petition in the courts. there are several orders that can be asked for, which one could be a temporary injunction until the matter is heard. So there are procedures, but it is highly possible that we might find ourselves after this election in that position where a petition would have to be determined in court. Very, very likely.
That could be the test for the judiciary of Sierra Leone.
But that's their job. So it's not a test. It's something that they do routinely. It's their job. That's what they're being paid for. That is what they're appointed to do. Just like nurses are appointed to look after patients. The job of justices in the judiciary is to do exactly that. Deal with difficult questions of law.
2007, the learned Chief Justice, Dr. Ademona Thomas, officially conducted an oath of office to His Excellency the President then and by Nkrumah while the SLPP party was taking the APC party to court on the grounds that the election was pretty much unfair. The indication is the one party may rush the court seeking for justice while administering the oath of office should have commenced, and automatically that seal has been given to the national seal has been given to the winning candidate, and there is no way such a decision could be overturned.
Well, there are provisions. If it's what I think you're asking, there are provisions in law that even if a candidate has been sworn in as president, if an election petition in the Supreme Court is filed and the court rules that that person has not been validly elected, then that election can be annulled. So it's in the Constitution, it's also in the Act, there's provisions in law for that. But that does not affect whatever work that president may have done in the interim. So whatever it is he has done is still valid. But notwithstanding, the petition will still be heard. And if the court decides to overturn the election results, then fresh elections will have to be conducted. So that's provided for in law.
It brings me to the other question for which many people has been battling to understand. Where petition has been made by Mr. A on the basis that Mr. X holds a dual nationality. The petition initially was raised at the district level, moved to the HQ in Freetown, and it was dismissed. Fast forward to this, Mr. A could say, well, or Party A could say, we'll take this matter to the Supreme Court. While the preparation for the imprint of the ballot papers have been made, if the Supreme Court eventually comes with a ruling that indeed the proof of evidence by Mr. A that you hold a dual nationality in the interim, should that hold?
I mean, when you say should it hold, I mean, are you saying, I mean, I need to
when
understand
all
what you're
other
saying.
things should have been proven right, he who asserts must prove. You've able to, provide enough evidence to the point that indeed Mr. A, in this case, I don't know of anybody, Mr. A holds a dual nationality, and that matter is taken to court, and the court sits on the issue. At the end of the day, they come out with a ruling that indeed the evidence before us is adequate for us to make a judgment that indeed you hold a dual nationality that prevents you from the presidency as well as becoming a member of parliament. Is that feasible?
Well, yes, it is. And if I recall the past elections we've had in 2007 and 2012, election materials were not printed until the very last minute.
Okay.
So if a court gives a decision, I mean, it's a question of printing ballot papers or whatever election materials that are required in accordance with the decision of the court. Because remember, the Supreme Court decision is final. So the Supreme Court takes a view that Mr. A cannot properly contest, then his or her name, whoever that person might be, cannot be on a ballot. So then NEC would not be allowed to put that person's name on the ballot. So they will have to print ballot papers without that name and omit that name from the ballot. So it is feasible. It's an operational issue. And it's something, I mean, printing of ballot papers does not take that long anyway. So even if ballot papers have been printed, the only issue would be NEC would obviously have suffered some cost in terms of printing ballots which then have to be discarded. but they will have to follow the judgment of the court. There'll be no excuses.
Conclusively, what are you looking forward to immediately after the elections with regards to, you know, well, putting more resources into the judicial system, and the expectation of lawyers in the states, especially the way they acted upon national issues. I have raised this question so many times, especially the Sierra Leone Bar Association. They should be seen central in, you know, undertaking. The last time President Ernest Bai Koroma challenged them to be commenting on national issues, especially issues that borders around constitutional matters. But I don't know. I will not take any brief for them. I honestly don't know. What are you looking forward to? Is it a new lease of life into the new dispensation of the justice system in the country after March 7?
Well,
are you hopeful?
Yes, I am hopeful, and I sincerely hope that whichever shade of government comes in, they continue in the process of improvements already made to the judicial system that we currently have. It's a question of looking at where we are now, then deciding where they want to get the judicial system to, and investing appropriately to make sure we get to that position. In relation to lawyers, I would expect to see lawyers doing their bit to ensure that the justice system can be moved forward, and in terms of attending courts, making sure that they can be as helpful.
I just stipulated penalties in a situation where lawyers could go to court and say, my lord, I'm not in position to actually attend this court. Do they take an excuse and all the rest of it? Are there stipulated penalties?
Well, I mean, I would say that when I was a magistrate here, I did not just simply accept when a lawyer comes to me and says, oh, I need to take a date. I needed to know why it was necessary for a date to be taken, having regard to the fact that this lawyer knew that this matter was coming up on this date. Because the practice in the UK, where I've spent most of my professional life, is the only way you can get an adjournment from a court in the UK is you would have to show what we call exceptional circumstances. That is, circumstances that are so beyond your control that it's almost impossible for you to have known about those circumstances, you know, before coming to seek an adjournment. Now, I have been in a court once where a lady, I'm a lawyer, she had childcare problems on the day of the hearing, and she attended court very late on that day, and the judge reported her to the Bar Council, even though she had childcare difficulties. And the judge's view was this: you knew that this matter was coming up, you should have made adequate childcare arrangements prior to the matter coming up. But if you leave it until the last minute and then your childcare arrangements fail, then you've been negligent in that regard. And that counsel was reported to the Bar Council and she was reprimanded. So that is how strict the system is, that you don't just walk into court and seek an adjournment on the basis that for whatever reason that might be. There have to be serious reason. Another situation happened where we had a tube strike in London once, and a lawyer could not get to court on time because there was a tube strike. And again, that lawyer was reported to the SRA, this is Solicitors Regulation Authority, on the basis that he knew that there was a tube strike and should have made adequate arrangements to get to court on time. So if we implement those kind of strict rules...
So in all of these, what underscore the element of timeliness of your process in court?
Well, strict. I mean, I made sure that I did not just grant adjournments willy-nilly. I made sure that if people want to take adjournments, I had to have good reasons. And even if I did grant an adjournment, it would be a very short adjournment, i.e. 1 or 2 days, to make sure the matter is not delayed. So I think these fall into the general domain. I think lawyers need to work with the courts to ensure that matters are not delayed unnecessarily. And I always say that it is not in the financial interest of lawyers to delay matters. Because when you're stuck with a matter, you're stuck with it. But if you get it out of the way a lot quicker, then you're going to be able to take on more cases and make more money. But if you have one case lasting a year, 2 years, 3 years, you still have to be going to court for that case. So it makes sense for them to work with the system, work with the justice system to ensure that their bread and butter can achieve the results that they want.
Adrian, conclusively on two things. Is the law profession just about the battle of wits, or is much more about reliance on the evidence to actually prove a case?
Well, it's a bit of both. Because you need the evidence. I mean, we have a saying that a lawyer is as good as his case. No matter how good a lawyer you are, if you don't have the evidence to successfully win your case, you're not going to win it. So you need to have the evidence, and then at the same time, you need to have the wits to be able to use that evidence in court. And there's one more thing you need to have sometimes: luck.
So in all of this, I put a question to you. Do you see yourself as a very fine lawyer?
Well, I certainly would leave that for others to judge. But what I can certainly say is I spent a considerable amount of time in this country as a magistrate, and I'm sure that by now people would have come to their opinions as to the state of my competency or otherwise.
If I ask Lawyer Gabidon to make an assessment of your professionalism, do you expect the best coming from him?
Well, I certainly would expect a honest comment from him, and I see no reason. I would not feel offended in any way by if the comments were otherwise than I expect. But I don't expect anything otherwise from him.
On this note, I want to thank you so much, Adrian Fisher, for joining me in this program. I must say it's wonderful having this privileged conversation around issues borders around the Public Election Act, and taking our time off straight off to talk a little bit about the law. Hoping to have you in subsequent editions. Thank you so much, sir.
Thank you.
This is how I bring the curtain into this edition of the program, Familiarise with the Law, with my guests, for which I enjoy this program so much, I must confess. Adrian Fisher. I have been the presenter, Abdul Rahman Kamara. The program repeat comes at 11 tonight. Stay tuned. Have a wonderful day.